Hi again, and welcome back. Attorney Steve Vondran, and welcome to another exciting episode of Litigation Whiteboard. In this video, we're going to be talking about the mandatory settlement conference. Okay, so this is really an important point. We are licensed practice law in California and Arizona. This is general legal information only and not legal advice. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so we are back here. We are talking about the mandatory settlement conference, aka the MSC. So if you get a notice and it says, or you're in court and the judge is saying, we're setting a MSC for this date or that date, you write that down and then you go look it up and you go, what the heck is an MSC? I have no idea. It's a mandatory settlement conference. Okay, so after your complaint, here's how it unfolds in real life litigation. You have your complaint filed, you get into this discovery process, you have formal discovery, you have informal discovery. We'll talk more about these things in other videos, but you get there and at some point before trial, we have the trial right here. The judge is going to set the mandatory settlement conference. What's that mean? That means all parties have to show up. They have to attend court that day. Now you can check, there may be some flexibilities in these rules. I've had cases where a defendant, like an insurance carrier, their client's out in, Timbuktu, Minnesota or whatever, they can't make it to the hearing. There are exceptions where you can phone in or be available by phone, as they say. But generally speaking, the judges want to get the parties there. They want to commit their time. They want to get them out to court, ready to discuss their case, possibly ready to settle their case. Doesn't mean you have to. There's no requirement that you are forced to settle your case, but it's a good opportunity before you get to trial, before you spend a lot of money on, 10, 20 days of trial. It's an opportunity to basically have your case heard by a neutral or by a judge and spend some time in court and see if you can hash out your differences. So what's the process? Basically, it's going to depend on your judge. Your judge may have some special rules. There may be briefs required. Check the box on that. There may be the judge may want to know, where have settlement talks been? What have you guys talked about? Where are we at in the process? Have you made any offers to settle? Do we have any? How far apart are we? You want $1 million? You want $5,000? Where are we? So you may be required to submit briefs outlining your position. You may be required to outline your legal theories, your facts, your evidence for your damages. So check with your rules, see what the judge wants, but make sure you're checking that out to see if you need something, okay? Now, what is the process? It's essentially mediation. So I'm going to check the box. Mediation. So you're essentially, again, you're not required to settle. Does anyone know the difference between arbitration and mediation? Mediation, you're not required. There's not going to be a judgment. In arbitration, usually an arbitrator is going to make a decision that's going to be final, subject to very little rights of appeal. There are some grounds. But mediation, you're going to talk back and forth. If you don't like the process, after a good faith effort, you can get up and walk and say, Judge, it ain't going to happen. We've tried. They're way over here. We're here. They won't listen. They think the law is this. It's just crazy, and we're going to walk. That's totally permissible, okay? And I have found that in some cases, it could be a neutral mediator that's appointed, like a retired judge or somebody in the court that is a lawyer who has done a lot of these, that does these all the time. And so they may submit a report to the judge. I usually ask, I said, are you going to submit a written report to the judge? Because what I don't want is my client asking for $10 million and the mediator thinks that we're just totally ridiculous and that we're not being fair or not playing fair. Not to say that this happens, of course, but I always check, is this going to be submitted to the judge? No. Okay. And I would say for the most part, normally it's not. But you get in there, you have a chance to mediate, you have a chance to settle your case, talk about the pros and cons. A good mediator is going to get the pros and cons to the attention of the clients. Because you got to understand, a lot of times you have a plaintiff lawyer and a defense lawyer. They're both vigorously advocating for their clients. Sometimes they don't see the other side's position very well, or they don't communicate it very well to their clients. And so this is an opportunity, if you have a good mediator that can get in there and say, hey, that you're never going to get that in as evidence. That's totally speculative damages. You're not going to be able to bring that into a court of law, or that's going to be hearsay. Your key evidence is no good. So this is a great opportunity to explore those kinds of things in front of a judge. Okay. What do we have? You can settle. Again, you don't have to. You can, if you settle. One other thing is make sure that there's a confidentiality, that everybody knows it's confidential. Your settlement discussions are 100% confidential. They are not admissible in court. They are not coming in at trial. So make sure that everybody's aware of that. Usually I like to make sure that's in writing somewhere, but they're settlement negotiations, okay? So you have a chance to settle, or if you don't, you get up and walk and you say, you know what? I'm going to trial, baby. I'm taking this one all the way to trial. You can do that. Okay, realize that there's going, obviously there's going to be costs involved, so forth and so on. But even when you leave, it's not like it's your last chance to settle. You could settle in here and here. You could do motions in limine in here and then settle. You can settle at the day of trial. You can settle after the opening argument. You can always settle. Sometimes people will ask me, Attorney Steve, when is the best time to settle? I say anytime the parties can come together and you think you've got a good number that makes sense, that's an adequate award for what your damages are, and vice versa, then that's a good time to settle, okay? So again, you can settle or you take it to trial. If you end up coming to an agreement, I usually want to make sure I get all the terms down, confidentiality, full release, who's being released, the release of indemnity, subrogation rights, all kinds of things, okay? You want to make sure you get them in there, and then usually what happens is all the parties will walk into court and you'll put it on the record, okay? So the judge may be there, judge may not be there, but you're going to put it on the record in front of that court reporter. You're going to say the parties have reached an agreement. I understand the terms. Your parties are going to agree in open court, and you're going to have essentially an enforceable agreement at that point, barring some, crazy mix-up or misinterpretation or something. And then after that, the parties are going to go back, prepare a formal written settlement agreement, and the case will eventually be disposed of. The case will be dismissed with prejudice or without prejudice. We have a video on that if you're interested. But that's a general overview of the mandatory settlement conference. There's no need to be scared about this, but you do want to be prepared when you go in. You want to have your evidence. You want to have your arguments. You want to have your damages evidence. You want to be ready to show that mediator and convince that mediator that you're serious, that you're willing to take this thing to trial. That's what I have always found that is the best key to success. And also to, set your sights high and give in slow. Don't just give up big chunks. If somebody's at, we'll settle for $500,000 and you say you want $1 million, you wouldn't say, okay, I'll settle for $5. You just drop $500,000. That could be a big deal. So usually you want to be realistic, drop in very small, what I call begrudging increments, and give in really slowly. And it may take some time to do these mandatory settlement conference. You could be there half a day. You could be there all day. But the goal is to give it an honest effort to see if you can save yourself these trial fees, get your case settled in a way that makes everybody happy, okay? And by the way, they also say in a good negotiation, everybody loses. Everybody loses a little bit. They don't get exactly what they want. They walk out of the court going, dang, I know I could have got more. That's usually the sign of a good settlement, okay? I hope this has been helpful, Attorney Steve. Litigation Whiteboard. If you liked the video, give us a thumbs up. That keeps us going, bringing these great videos to you. You can also share this on your social media networks. Make sure to subscribe. We're going for our goal of 10,000 viewers. We're going to try to hit it this year. We really want to get there, so if you can help spread the word, we really appreciate it, okay? Attorney Steve Vondran, thanks a lot. I got to get running. Got to get back to work. We'll talk again. Bye now.